We can start our meeting. Please ask the officials to come in. Yes, if we have something urgent, we'll ask you to come back. And also, if you have time, please also help with the scrutiny. Members, we are now in the process of the cross-by-cross examination. Actually, we started that some time ago, but we discovered later that there are still questions that we need to put to the administration, so that the cross-by-cross examination was suspended, and now we can return to the cross-by-cross process. We have covered the interpretation, the short title, and commencement interpretation, and so on. I don't think we should repeat what has already been discussed. We have talked a lot about the terms in the interpretation section. And Ms. Elizabeth Kwok, I do not object to the continuation of the cross-by-cross examination, but perhaps the administration can tell us how the discussion with the Privacy Commissioner for Personal Data went, and then we can proceed. Ms. Elizabeth Kwok wants to know about the discussion with the Privacy Commissioner concerning the Commissioner's proposed amendments. I hope some consensus has been reached. And please also tell us what clauses in the bill will be relevant to your discussion with the Commissioner. Mr. Chan, we are actually in discussion with the Privacy Commissioner on two issues. First, the need to know principle. Second, we want to adopt this concept of a safe deposit box without imposing too much restriction on the system. With regard to the need to know the principle, we've agreed on the wording, so this is more or less resolved. Second, adopting the concept of a safe deposit box. Well, actually, we share the same thinking, but in terms of the wording and also where this concept should be incorporated, we have some different ideas. The Commissioner would like us to put it under the consent stipulations. But we would like to have independent clause to put more emphasis on this concept. We are still working on the drafting. If it's an independent clause, where is it going to be put? I think it's about clause 16 or clause 17, somewhere between those clauses. What about the wording? Are you going to change the wording proposed by the Privacy Commissioner? We are still in discussion with the Privacy Commissioner. No consensus has been reached, but we are in agreement 80 or 90%. Are you going to have another meeting with the Commissioner or what? We are going to present an agreed version with the Privacy Commissioner to Disputes Committee. Can we be given the text before the next meeting? When is it going to be? The 9th of February? Yes, because we don't want to hinder the progress of the cross-by-cross examination. All right, let's hope you can give us the draft as soon as possible, so that we don't have to skip the two clauses. All right, we now proceed to part 3. Substitute decision maker. Who from the administration team? Are you talking about the definition? I was under the impression that we were on cross 5 last time. Cross 3, substitute decision maker. Yes, we did cover that. We haven't covered cross 4. We did touch on cross 3, and I'm not sure that was completed. Because at that point, some members raised the point that we were in too much of a rush to go to cross by cross examination. So members, do you have further questions regarding cross 3?
Dr. Fernando Zhang. Dr. Zhang, this is also the point you mentioned, Mr. Chan. Can you remind us? You are still waiting a reply from the LHB, right? Yeah. The LWB, yes? Yes. Dr. Zhang, my prime concern is that for someone above 16, that person is, more like an adult. So when it comes to dealing with the e-record, in the decision making in relation to access or participation, well, there is a statutory definition for incapacitated person, but there is actually a spectrum in between that. Lots of them will have the ability to do certain things, but between that and MIP, say for example, those who are living in residential homes, they are actually MIP, mentally incapacitated person, and there are no family members nearby to help them make a decision. Say it's a lone elderly person living in a home with no family, but the say the private home has already got that person's passbook to make all the decision for that person. So who will be the substitute decision maker? Who is the person who thinks he or she has the responsibility to make decision on that person's behalf? So can this provision deal with this matter? As we've explained, the job of a substitute decision maker is to make a decision on behalf of the patient to participate in this scheme and to decide which participating private hospitals to share the records with. Well, of course, if the patient, him or herself, has the ability to do so, then the decision will be made by them. But in some cases, say for example, a child, then you will need someone else to make the decision. That's why we have the substitute decision maker. There are also persons that are, say, an adult, say 16, but they don't have the ability to make a decision. So there will be the substitute decision maker to make a decision for say, for example, this person to decide to participate or not in the scheme. And this group of people may include a guardian appointed by the guardianship board or a person appointed by the court, and in some cases someone from the social welfare department. And in some cases family members may be the substitute decision maker. And if none of the above exist, it may be the healthcare providing institution, say for example residential care home. But we're referring to a home that has engaged healthcare workers. And of course, if there are family members, then it will be the family members who make the decision. My question was the responsibility. Who bears the responsibility. Say, for example, I am the owner of a private home. I have recruited a nurse to oversee the operation and the condition of the inmates. Maybe the nurse think that he or she has no responsibility, and I, the owner, may not think that there is any responsibility. So who is supposed to do it? It may be stated in the law, but there may not be anyone to enforce it. So this responsibility, is it an actual responsibility under the law? Are there any measures to provide the incentive for the nurses, the private homes, to make the decision, Mr. Chan? But this is not a mandatory scheme. So the healthcare provider or the family members don't have the responsibility to join the scheme by obligation. But we hope that the carer will explain to the patient what this is about as far as possible. And we also require the healthcare provider, in making the decision, should base the decision on the best interest of the patient. So if it is not a legal responsibility, are there any measures to promote or encourage the providers, institutions, and individuals to participate in the scheme? Will this address Dr. Cheung's concern? A few months before we launch the scheme, we will mount a large-scale publicity campaign. And we've always explained that the scheme is most effective for people who often use private or public healthcare services and elderly people, because sometimes they have forgotten which doctor they've seen and what medication they have taken. So the e-record will have a record of what they've taken and who they have seen. And a lot of these elderly people are staying or are cared for in homes. And the third group is children. And we would like to keep a health record for the children starting from a young age, say, for example, from vaccination age. The first round of publicity will be by means of outreaching activities to child and mother and child care center and health center and RCHEs. Well, you say that it is voluntary. This voluntary electronic health record sharing system, it should be beneficial to patients, and it is an improvement. I think the objective of the system is to encourage as high an uptake as possible. Since it's voluntary, then there will be people who can't make a decision, and there's no one near and there's no one around who realize that they should make a decision for these people, so they've been left out. And in a way, this is discrimination. This is a good system. It's an improvement. It will provide better care for the patients. And for a group of people, we know that they don't have the capacity to make a decision, and there is no one around to make a decision for them. This is a loophole. The law should state that in this instance, then someone should be appointed to make a decision for them. Say, for example, a primary health carer. If there is a statutory procedure involved, there is a guardian appointed by the court, of course, the guardian will have the responsibility. What about those without a guardian? Well, say there is such a person. Will there be a unit or an institution who will tell that person a decision is to be made? If the patient can make the decision, him or herself, then the decision will be made by the patient. And if the decision is made by a substitute, do we give the power to this substitute? That the substitute decision maker should make a decision? The power may be excessive. Well, in the case when it's a mentally incapacitated person, then yes, there should be a substitute decision maker to make a decision that is in the best interest of the patient, but it should not be mandatory. All we can do is just to encourage and promote the scheme to decision makers. We can't force the decision makers to get them to say yes. Well, I think my question has been misunderstood. All I was saying was that there should be a substitute decision maker to consider this matter and then make a decision to whether to participate or not. If say, for example, that decision maker thinks it's in the interest of the patient to not participate, then the decision will be a no. So, in a case of an MIP, there is a substitute decision maker. The administration will promote the scheme to the decision maker so that the decision maker will know about the scheme. In this case, it's no different from a person who has the capability to make decisions, him or herself. And it's difficult to state by law that the decision maker should make a decision, and there may be more than one substitute decision maker. All I'm saying is that the case is no different from an able person. I may be able to make a decision myself, but I may not know the merit or disadvantage of the scheme. And I think for people who will benefit most from the system, say for example they have the need or they are frail, the difference may be very little compared with an able body. Well, if there is no way this can be promoted, then there is no point discussing this. But if it can be promoted, if the decision or the person concerned knows about it, then a decision can be made. But what about an MIP without a decision maker? Who is there to take care of them and decide for them? This group of people is neglected because they cannot make a decision themselves. Publicity to them will be useless. However, there is no substitute decision maker. What is to be done? For this EPR PPI, the one-way sharing, what is the registration rate for the groups mentioned by Dr. Zhang? Can you make a comparison? Say the homes or these institutions have been quite active in signing them up for this PPI EPR, then in the future it's very likely for them to continue. And it means that publicity for the pilot scheme was effective. Then we will have more confidence. So what is the actual situation? Do you have the figures for our reference? Well, for this one-way PPR EPR, there are 450,000 patients participating, and out of this group, a lot of them are staying in care homes and nursery homes. We will try to dig the figure up. Ms. Lee. As at the end of 2014, the age group distribution of the 450,000, well, over half of them are over 65. For those who are over 55, over 70%. So there are quite a lot of elderly people participating. And in terms of healthcare institutions, there are RCHEs because we promote the scheme to them as well. Dr. Wong, something to add? I understand Dr. Jones' concern. Well, my colleague is in the process of looking for the number of RCHEs that have participated in the pilot scheme. We see that there is incentive for the homes to participate in the future EHR scheme because it will be easier for them to pass on the medical information to the healthcare workers. Better care will be given to the inmates. It's just that in the past there isn't any convenient channel for the information to be passed on to the healthcare workers by electronic means. With this bill, different people can be a decision maker, including a person in charge of the homes.
When healthcare providers participate in the scheme, they will be informed that they will have to comply with certain code of conduct, and joining the scheme is easy for them. Although this is a voluntary scheme, for those who can make the decision for themselves or for those who cannot, this is voluntary. But we are here to help the patient. So even for people who cannot make a decision themselves, joining the scheme is easy. We are going to do some publicity, and proper guidance will be provided to advise people on how to join. Of course, we will monitor the progress after the implementation of the system. So perhaps you can give us some data concerning participation by RCHEs, and if they are already in the pilot scheme, then chances are they will also be willing to join the new EHRSS. But I don't think a solution has been found for the question of principle that I have just mentioned. There must be someone who can make a decision for these incapacitated people. The owner of the RCHE may think that it's better not to join the scheme on behalf of the patient. But the private doctor may have a different idea. So the law must have clear stipulations on how to help these people in the middle of that spectrum of capacity. And these people cannot make a decision themselves. So we need to know two pieces of information: the current situation, and second, the scenario, the hypothetical scenario, which involves a question of principle, as mentioned by the member. But this is a voluntary scheme. It's the nature of the scheme. So we would try to not to omit anyone in coming up with the list of substitute decision makers. If there's no guardian for a person, that there's no court order for his guardianship, and there are no family members that can take the decision for them. So should we allow the healthcare providers, including doctors, nurses, and the homes, to make a decision for them? Under clause 6.5, in making a decision, an application, a substitute decision maker of a healthcare recipient must have regard to the best interest of the recipient. So the doctor or the RCHE must have regard to the best interest of the person concerned. But I think Dr. Zhang's concern is that this is not good enough, because this is what the decision maker should do when making an application. But the concern is that this substitute decision maker will not even try to make a decision. But you are not just saying that it's mandatory. What they are required to do under the law is to come to a decision. Actually, we are talking about a prospective participant of the scheme. It can be any one of the 7 million people in Hong Kong. And we don't know for each and every one of them who the substitute decision maker will be. It's rather difficult to cover all cases in drafting. There's another question. When there are different substitute decision makers coming to conflicting views, what should happen? What if there's a dispute? For example, we mentioned the example whereby the siblings could not agree on what to do. And maybe the healthcare professionals may even have different opinions that cannot be ruled out. What's the administration's take on how to resolve this? For the PPI, EPI pilot project, we do not have any information on whether the decision is made by a substitute decision maker, because we don't have the law to stipulate this. So this is proposed in the bill to make up the loophole, to make up the shortcoming. So what happened now under the pilot project? Well, the claim will be that it's the decision made by the healthcare recipient himself, although the advice may have been given by the home or the family members. That's why we want to propose this stipulation in the bill. So in that case, you don't have any information to answer my question. Or all they can do is to find the ratio of participants, healthcare recipients who are already living in a home. You can just have some general data, but you will not know how or who made the decision to sign up. The current pilot project, it works under the presumption that every participant joined of his or her own accord, because there's no substitute decision maker. So will the homes be proactive in making such a decision on behalf of their residents? My colleagues has given me some data. As at December last year, under the PPI ECR, 2,488 doctors have joined the scheme. They come from 78 institutions, and under which 439 homes are involved. At present, under the PPI EPR, the patient has to sign up himself. But since we want to have more patients participating in the scheme, that's why we want to introduce the concept of a substitute decision maker, so that decisions can be made for mentally incapacitated persons. But sometimes residents in the homes are also in the same situation, and they cannot make a decision. At first, we talk about A under 3, mentally incapacitated as defined by the Mental Health Ordinance, and also B, those incapable of managing his or her own affairs. And so the the substitute decision maker can be a family member, or it can be a guardian appointed under the Mental Health Ordinance, or someone appointed by the Director of Social Welfare, as well as health care providers. We have make reference to overseas practices, and that is when there's no one who can make the decision, we would allow this to allow the substitute decision maker to make a decision. But this is unlike the person appointed by the Mental Health Ordinance. So this substitute decision maker should consider whether this is beneficial to the patient, and the substitute decision maker will shoulder some responsibility, and there's no benefit to him. We understand that this is an improvement, but we want to make sure that the new stipulations will have as little shortcoming as possible. So this substitute decision maker can be a family member or a home and a healthcare provider, but there are still some questions. First, you allow these people to be substitute decision makers, but they are not obliged to act in such a capacity. So there may be cases whereby no one is willing to be the substitute decision maker. And what if different substitute decision makers have conflicting views? And you will say it's up to them to resolve their differences. It's not really a solution to the problem I've raised. If there's no guardianship granted under the Mental Health Ordinance, or the guardianship law, so who should bear the responsibility of making a decision on behalf of that incapacitated person as regards whether to join the scheme? There should be clear stipulation. And if if different substitute decision makers have different views, who should be the final arbitrator. For example, a case should be submitted to the guardianship board or to the court for a decision. I think we should find some solutions instead of letting the problem dangling in the air. With regard to the second point, we've spent quite some time on this issue. Maybe you should consider how to address the second part of Dr. Zhang's question. Well, I think there's an important principle involved here. The decision maker will make a decision on behalf of the person himself. So the power that the substitute decision maker enjoys is the same as that of the person himself. Now, this is a voluntary scheme, and nowhere in the bill can we find a stipulation that the person must consider whether or not to join the scheme. There's no obligation on any person to consider whether to join. And if the substitute decision maker is enjoying the same power of or shouldering the same responsibility of the person, then he is not going to be given more responsibility than what the person would be required to do.
Well, I have to add, given the answer of the administration, I don't want to use so much time, but we have to protect this underprivileged group, because this group of people don't have the ability to make a decision. So the patient can't give consent. How can you make a direct comparison between an able-bodied and someone who is incapacitated? Say, for example, cash payout by the government of the 6,000. If you're over 18, then you decide whether to take the 6,000 or not. But for someone who doesn't have the ability to make a decision, he simply can't understand what is going on. So someone needs to make a decision for that person, and that someone should consider whether it is in the good of that incapacitated person to receive the 6,000. But now, no one knows who this substitute decision maker is. It can be the doctor, it can be the home, it can be a doctor in the home, it can be the person in charge of the home, or a family member. That is the case. You can't say this is voluntary, so you decide. And if you can't make a decision, you get someone else to make the decision for you. But anyone can be a substitute decision maker. No one knows whether he himself is one. So there is a loophole. I think you're talking about the second part. Well, we have had a long discussion about the first point. I don't know whether you can convince the other party. But if you can't convince the administration, you may have to find another way to deal with it. But for the second part, we might have had a discussion a long time ago, but this time you have not answered. So what about the case when there are more than one substitute decision maker? I think this is related to 3(4). That is, in the case of someone who cannot make a decision. Say, in F, in the absence of the persons mentioned in A, B, C, D, and E, that is, those people who have the legal responsibility, say, for example, guardian or the care home itself, say, for example. But when none of these exist, then it's the case of F, an immediate family member. And in the case when there is no immediate family member, then it will fall onto G. That is, it's for the healthcare, for the home or the social welfare department to make a decision. But what about when someone has family members, but the family members themselves have different opinions? It's difficult for us to decide which family member is more important than others. And we can't say the mother is more important than the father. And this cannot be resolved. And well, it happens that there are always such disputes. What we can do is to ask the parties themselves to have a discussion, or to get, say, nurses or social workers to get involved. We're not talking about a time when treatment is required. It's not the case that if you don't join and at that very moment your life would be in danger. And given the constraints, this is all we can do. Dr. Zhang? So this remains unresolved. My proposal is very simple. Just refer it to a guardianship board or the court and get them to decide, because now we have a guardianship system. You can amend the guardianship. So when there are disputes as to who is the substitute decision maker, then the court or the committee will decide who should be the substitute decision maker. Well, this will be related to the expansion of terms of the guardianship board. It is not under our purview. Perhaps we will refer this to them. Yes, you let them know and we will await their reply. And we will take it from there, because your views are very clear. So, any other questions when it comes to clause 3? Legal advisor. I have some views about drafting of clause 3. Please refer to 2B. Appointed by the court, 獲法庭委任. It refers to Cap 13. We've referred to the wording, and it should be better draft. It will be a better draft is 獲法院委任, appointed by the court. So this appears in 2B, 2C, and 4E. B, 2C, and 4E. 獲法庭委任, appointed by the court. The Chinese rendition I think should be changed to 獲法院委任. A different word is used. Thank you, legal advisor. Another point is subclause 4, paragraph F. English, it reads immediate family member, which reads, say, for MIP, and in the absence of persons mentioned in paragraphs A, B, C, D, E, it will fall onto an immediately family member to be the substitute decision maker. The Chinese rendition is 家人 family member. So the English rendition, the scope is narrower because there is the word immediate when it doesn't appear in the Chinese rendition. In Cap 527, the Chinese rendition 直系家庭成員 is used to refer to immediate family member. We've asked the DOJ whether they will consider this. They say that under the PDPO, when immediate family member is used, the Chinese rendition 家人 family member is used. So when you read the Chinese version, more people can be your family member than in the English version, immediate family member. So what is the meaning of immediate in other provisions? Well, this is defined in C1207 is immediate family member, which says 家人. So it's in relation to a healthcare recipient, meaning an individual who is related to the recipient by blood, marriage, adoption, or affinity. Miss Helena Wong. In 4F, I think the scope is wider. Because it's someone who accompanies the recipient, so it can be a friend. It can be a helper or a neighbor. But in Chinese, it reads family member. Ms. Choi explained that the English term immediate family members include those related by blood, marriage, adoption, or affinity, so it's rather wide. It's just that the term is immediate family members, which gives the impression that it's quite narrow. But if it's by blood, your cousin is related to you by blood. Well, it's a family member. What about a same-sex partner? Right now, we don't have same-sex marriage for someone who lives with that person, with the recipient. Would you treat that person as a family member? Well, our marriage ordinance is very backward. It doesn't deal with cases involving same-sex cohabitation. You have to clarify this. Otherwise, the same-sex partners cannot become the substitute decision maker. So how do you deal with this case? Well, I've heard two issues. First is the Chinese and the English version. English is immediate family member, whereas the Chinese rendition is 家人 family member. As we've explained, that we have to align it with the PDPO, and we try to mirror the PDPO. And the definition of 家人 immediate family member is already in C1207. Is someone who is related by blood, marriage, adoption, or affinity. So it can be quite wide if it's related by blood. Well, so the scope is rather wide, and we don't have same-sex marriage legislation. So we have to follow the existing marriage ordinance. But we don't recognize same-sex marriage. And our marriage ordinance is backward. You know full well that there is a loophole. You can't just ignore that. When we deal with domestic violence, well, when it's same-sex cohabitation, they are still protected by the law. You've forgotten about this. We don't recognize same-sex marriage, but still, same-sex cohabitant are protected. You cannot ignore that it may happen to same-sex relationship. You can't neglect this group of people simply because a same-sex marriage is not recognized. It can be dealt with by the domestic violence and cohabitation ordinance. I suggest that this is to be dealt with by the administration, otherwise we will move amendments. So it can be dealt with by the domestic violence and domestic violence ordinance. But that is not under our scope. So this is rather fragmented. Can we ask the legal advisor? If you don't have the information, well, just go back to find the information. We've dealt with it under the domestic violence ordinance.
一個問題比較下，即係兩者嗰個情況有冇啲可以
So, legal advisor, please check if there's something we can make reference to. First of all, I'm sorry that I did not participate in some previous rounds of discussion, and I'm happy to be here for this cross examination. First, I want to say something about domestic violence ordinance. We're not just talking about same-sex couples, but even cohabitees are protected under the domestic violence law. There was a comprehensive discussion, and these people enjoy certain status in that ordinance. I hope we can borrow something from the domestic violence law for this bill. I'm not talking about same-sex cohabitees, but also heterosexual cohabitees as well. So you may be related to your aunt by blood, but not to your uncle-in-law. So how far removed will still count? So that we are talking about relatives in an extended family. You may have in-laws, your uncle, who is not related to you by blood. Well, actually, there's another limb who accompanies the healthcare recipient at the relevant time. I don't know whether this means that he's living with the patient or he's taking care of the patient. What if that family member is taking care of the patient, but the relationship is a bit removed? And also there's a question of the translation of immediate family member. It can be sometimes translated in Chinese as a 直系親屬. But you want to copy the privacy of personal data protection ordinance. That may be the case for one ordinance, but there may be 10 or so other ordinances which do not translate the term in the same way. I think we should find out why, when the PDPO was enacted, that the translation was not a direct equivalent to the English term. Well, I personally did not take part in the scrutiny of that PDP bill. So you should find out why it was translated in such a way. Also, we say that we should rectify the situation starting from this bill, and then the PDPO should be amended when the opportunity arises. Mr. Chen or DOJ, can you provide a response? Well, as I have explained, we'd like to align the term with the one in PDPO. In the definition, we have defined family member, immediate family member, as someone who is related to the person by blood marriage, and so on. Is there a table in the PDPO saying that you are related to a person, to a father of your distant cousin, and so on, would still count? So we have to find where the line is drawn. First of all, we want to get someone who can make the decision, but we don't want to be the relationship should be so distant as to cover so many people. But we're talking about the one who accompanies the patient. We're talking about at the point of making the application. It can be a distant relative who has come back from a faraway country. Yes, we're talking about the person who's there at the relevant time. And the person can be a substitute decision maker. Can we get some answers for more simple questions? For example, what about uncle? For example, the husband of your aunt. Can there be a combination of different factors, blood plus marriage plus affinity?
長咧頭先就係講私隱，即係佢關注到私隱嗰度多啲，即係唔可以去。
I think they are concerned about privacy, and then they don't want to stretch it too far. We're talking about two things. First, we're talking about the carer, and the wider the definition, the better. We want more people to have the status to take care of the healthcare recipient, and at the same time we want to protect privacy. So can we take care of privacy concerns while we provide a wide definition of family member or carer? Can we just have some answers here? I'll ask Ms. Lee and my colleagues from the DOJ to tell you the line that we have in mind. For example, brothers-in-law, sisters-in-law, your father-in-law who are not related to a person by blood. But there's also the concept of blood and affinity. What about those who are related to you, your spouse by blood? Well, we want to make it convenient when we define who are substitute decision makers. So apart from aligning the definition with the PDPO, it's also in line with the Family Status Discrimination Ordinance. We are talking about blood, marriage, adoption, and affinity. But we cannot provide a full list for the category of affinity. But under the definition of affinity, your father-in-law, your brother-in-law, your sister-in-law will all be accepted. So why do you need the word immediate in English? Again, this is because it's in the other ordinance. So perhaps you can tell us the reason why.
本唔對稱嘅情況出現咯。
好，
即係如果
Why is there a mismatch?
其實英文裏邊冇 immediate 係唔緊要嘅。咁我
And then we will stop. You can asking further questions. Want to know why there's a mismatch?
資料嚇 OK。咁黃碧雲議員，
主席，我都係想做。
Dr. Helena Wong. 4F. Family member doesn't cover cohabitees, heterosexual or homosexual. I think they are not covered. Are you going to amend it to cover cohabitees?
件事第一個咧就係喺我哋其實當
Mr. Chan, when we drafted the consultation document, we stated that we will not cover cohabitees, heterosexual or homosexual, because we want to make sure that the relationship between the person and the substitute decision maker can be ascertained. If it's a marriage relationship or it's a father-son relationship, we can really ascertain that. But for cohabitees, it would be difficult to prove the cohabitation. So why do I accept this person to the register on behalf of another person? So that's why we have adopted this drafting. And that is, we accept a relationship based on blood, a marriage, adoption, or affinity. Since cohabitees are not covered, what about domestic violence ordinance, and why it's okay with the domestic violence ordinance? I don't think you can brush it aside. If it can be done under the domestic violence ordinance, if that can be done, why can't you do it here? Even for marriage, you may have people who are living apart. We have to bear in mind that there are many forms of family relationship. You should try to find out how many people are in cohabitation. Are you going to leave out all those people? I think different laws would have different policy considerations. I'm not familiar with the law on domestic violence, but I think it's for the question of protection against physical violence on the person. But for other government schemes, whether it's HOS or other allowances and subsidies, cohabitees are not yet covered. So different laws may have a different background. I think the Secretariat and my colleagues can of course try to find out the the clauses, the sections and stipulations in other laws, but I don't think there's any consistent approach here. I need to take this up with Mr. Chan. We have Muslim families, and some of the families have 4 wives. So we will be as generous as we can in terms of protection, but in terms of welfare, we will be strict. Although I don't agree with such an approach. But this one is not going to incur any additional public expenditure, because we're talking about healthcare providers, public or private. So of course you are not going to allow cohabitation to be considered in granting welfare payments or tax allowances. So I can just quote this example of Muslim families in Hong Kong to illustrate this point.
同埋我哋同事都要翻去即係。
The Secretariat and ourselves will go back to look at the similar legislations. And as to whether it's to the level of protection, I think we're not that level. And it is not a welfare either. And we will take that into consideration and we'll give you a reply next time. Ms. Wong, you've finished? Dr. Zhang. I agree that when it comes to same-sex partners and cohabitation, that's also an area of concern. I asked the administration to consider whether to expand the scope of protection. I note that when it comes to the substitute decision maker, for people who are under 16 and those above 16, there are differences with their substitute decision maker. For those under 16, it's family, immediate family member, healthcare provider. So first, immediately family member, and of course before that there will be some court procedure for an appointment. If there is no such appointment, then it's immediate family member. Without that, it's a healthcare provider. For those above 16, there is no healthcare provider, so there is a court procedure for appointment. Failing that, immediately family member. Failing that, no one. Yes, there is healthcare provider. It's stated last over the page. So the flow is the same, yeah? They align, yes. So the safety net will be the healthcare provider taking care of the recipient. Is it only in relation to an emergency or not? No. No. Other follow-up questions in relation to clause 3? If not, yes? Legal advisor. (3)(1) There is a term, healthcare recipient, 醫護接受者. I would like to refer to the definition of this term. Healthcare recipient is an individual for whom healthcare has been performed, is performed or likely to be performed. So there is a drafting problem because the angle is different. In English, the healthcare recipient is an individual for whom healthcare has been performed. So this for whom healthcare has been performed is changed in the Chinese rendition. So whether it's in English, whether it's perform or recipient, the Chinese rendition is 接受 for both terms. I've written to the administration to ask them to consider consistency. So will there be a case, say, when the healthcare has been performed before the recipient actually gets the healthcare, because maybe it's for the doctor to prescribe something and it will have to be performed by someone else onto the patient. So will that be the case when it is performed but it is not yet received? I understand that, well, according to the administration, they say that it's not a direct translation. But I would like the administration to consider that when the angle is changed, so the healthcare is performed, but the patient has yet to receive it. When it comes to healthcare Chinese is 曾經正在相當可能接受 is has or in the process of or likely to receive healthcare. So whether it is the English version or the Chinese version, the scope is rather wide. And as to whether there is a change in angle, one from the healthcare provider, the other one from the perspective of the recipient, I will defer to the DOJ. This is a drafting issue. Ms. Choi, for the English version, the concept of perform is on C1207. It stems from healthcare because it's an activity performed in an individual, means an activity performed in Hong Kong for an individual. And then when it comes to the healthcare recipient, it is along the same line. An individual for whom healthcare has been performed, is performed, or is likely to be performed. So along a logic, so when healthcare is performed on someone, the fact is that the patient has received it. I will defer to Dr. Wong. I agree with the DOJ. Well, once the healthcare has been performed, then the recipient has received it. Perhaps you may understand it to be, say, transfer service. And the service has, the patient has yet to see a doctor after the case has been transferred. So whether it constitutes service transferred. Well, a doctor may refer a patient to another doctor. Then service has already performed. And since the patient has received the transfer from the first doctor, although the patient has yet to see the second doctor, service has already been performed. So when healthcare has been performed, then the patient has received the healthcare, and in this case, the patient can participate in the scheme. Legal advisor. Well, I'll leave it for members to consider it. when it comes to healthcare provision, there is a time element. Say, for example, prescription of drugs. Say the record has been entered, but you have to go to the dispensary, and then the nurse will have to give the drugs for the service to actually be received. Yes, I know that for doctors, they see it as they see the whole picture. But when it comes to the actual detail, is it the case that once the record has been entered into the computer, it is the same as when the patient has already taken the drugs? So what about someone who thinks that he is a healthcare recipient, but he has yet to take the medication, so he is actually not a healthcare recipient? Will there be any implications under the law, under the bill? Will he be deprived of certain rights, or is that possible? We will have to mull it over, but it's best for the definition to be consistent. Yes, because this is an important term, healthcare recipient. As long as the Chinese follows the English or vice versa, that will be a simple matter. And I think the problem is in English, the term for whom is used, which is a rather indirect style. I understand that it will be different for the Chinese to correspond with the English, but you have used you have used a different angle. One, something is performed, and on the other, something is received. Ms. Ho, when we understand the term receive, say it's like opt-in. There is a role played by the recipient. When you are provided with a service, is different, albeit a minute one, from service received. So there is an element of opt-in because you have been performed a service. So, say in the case of a transfer, the recipient may not have an active role to play. I understand what the administration, where the administration comes from. Say, once a file is created, then you have received the service. But that is not the ordinary understanding of the word. Well, as we've explained, the Chinese rendition is not a direct translation of the English version. So there will be different way of drafting with the same effect. And as to whether, because of this, there will be different interpretations, I think that will be a more important issue. When we reach clause 6 or clause 7, we'll talk about healthcare recipient. We will go into detail what they are actually. And in that context, we will look at the two renditions and the seemingly different difference in angle. Maybe that will be better. Do you agree, members? Legal advisor. In the reply from the administration, they said that if healthcare is performed on certain person, then that person will have received that service. Say, for example, well, some medical blunder, a service is performed on A but is wrongly performed on B. So can you say that when it's performed, A has received it? Will you consider it? I think if this only about drafting, I don't know whether if you change it, it will make the Chinese version a mouthful. Would it be better if you align the two? Would you consider that? Well, we'll see what the DOJ thinks. We will later go to healthcare recipient. Well, we're actually talking about who is eligible to join the scheme. I think that there will not be a difference in meaning. Perhaps we will go into detail when we reach that clause. I don't think members will object to that. That is to align the two renditions. I think the new law draftsman is quite stubborn. Yes, Chinese 接受醫護服務 receive healthcare. It may be smoother, but if there is a difference from the English rendition, however minute it is, then I won't accept two different versions, because when you go to court, you can choose either version. So if you choose a certain version, then your rights will be different. I don't think that will be good.
係寫法律係好困難嘅，係寫到好唔似樣嘅。咁但係
Well, they don't look like each other. I would like to make sure that the context or the concept remains the same, although the wording may be different for the two versions. All right? Other questions? Clause 4 is simple. This ordinance applies to the government. Well, sometimes they are reluctant to spell it out, and the government can get away with it. Okay, that's a comment with regard to all the laws of Hong Kong. We have to read clause 4 with clause 57 and clause 58 on the exemptions or the exclusions. I propose that we should look at clauses 57 and 58. What should we do? Should we look at the two clauses now? It's fine by me. There are always limitations. Shall we take a look? I think we should look at the other two clauses in order that member will understand the effect of clause 4. So the legal advisor is saying that it's just like other ordinances. Although under clause 4 the ordinance applies to the government, that there are exclusions. For example, 57 bracket 1, the government or a public officer is not liable. But we're not talking about, we don't know whether it's a criminal or civil here. 58 bracket 1, a person to whom this section applies is not civilly liable for an act done or omitted to be done by the person in good faith. It will not just apply to a public officer. but also any officer appointed by the Commissioner. And it can be a non-public officer. Are they committee members? I think we have to get an answer from the administration. All right. So, as advised by the legal advisor, we should look at 57 and 58 first. So, I would like the administration to answer the questions raised by the legal advisor. And my own question is this: after excluding all these, what is left in terms of liability? I'll talk about the general situation. In other laws, there are stipulations to protect the public officers, and that is to say, to spell out under what circumstances a public officer will be liable and under what other circumstances he will not. This is necessary. For example, in Clause 58, if a person, a colleague, has done something in good faith, then the colleague will not be subject to the risk of a civil claim. So this is the general principle, and we want to reflect this in clauses 57 and 58. As for why they are drafted in such a way, that I'll defer to my colleague from the law draftsmen. Well, it reflects the policy. It said that not liable only because, and that is because they are not going to be liable just because they have done something. But of course there are other background factors to consider, and there may be grounds on which a public officer will be held liable. The drafting is similar. It's a general stipulation. I wonder if my colleague has anything to submit. So under what circumstances would it still be possible to hold public officers liable? Do we cover government doctors here and HA doctors here? And also healthcare providers? This is not limited to F&H Bureau colleagues. We are also going to involve HA colleagues in implementing the system. So apart from public officer, there are other persons appointed by the commissioner, and they will also be protected under these two clauses. In other words, HA people working for HA would also be covered. I'll ask Ms. Choi to elaborate. HA is also a healthcare provider, and HA is no different from other healthcare providers in this scenario. This section applies to a person appointed by the commissioner under section 48(3). And it's also said that the commissioner can appoint someone in writing for the purpose of performing a function. The commissioner cannot do everything himself. It's a big computer system, and the commissioner needs to appoint people to help him. And some of the IT people in HA will be helping us in the future in the maintenance and operation of the system. They may be HA people, but they may not be doctors. But these people will be providing assistance to the commissioner, and they will be appointed in writing before that they are covered by the protection under Clause 58. In the future, if the Commissioner appoints a contractor to upgrade the system, then the contractor will also be protected under this clause. Well, in the Health Services panel, the same point was raised. This is an important system, and members of the panel welcomed the role of the HA to be a kind of advisor. But of course, HA also outsourced some of its functions, but they are not appointed by the Commissioner. We're not talking about the executive powers here. Here we're talking about those who are appointed to help the Commissioner in discharging his functions and duties. And only those who are appointed by the Commissioner will be covered. And now the government invites or appoints the HA to be the developer of this system, so they are protected, or they are the HA and its staff. I believe its staff, the staff responsible for development, will be protected. Or anyone appointed in writing, the specified persons. Let's say the entire development team will be appointed without specifying individuals' names. But if it's outsourced, then the contractor will not be covered. Well, that's a problem. What do you think, members? Second, it cannot be ruled out that in the future, the Commissioner would say that I will try to get a private organization to do the same job instead of the HA, and then the same principle applies. Depending on the writing, on the appointment in writing, the outsourced contractor can also be protected. Is this the correct understanding? I think the chairman is concerned whether the scope of protection is too big or covers too big a field. In the initial stage of running the system, we will try to cover the public officers and the HA employees who are doing this for us. Under Clause 58, Bracket 3, Bracket B, the Commissioner may appoint someone, and also the Commissioner can appoint anyone to help him performing a function. So in the future, instead of appointing the HA, the Commissioner may appoint another one, and should that one be covered equally? But only those who are appointed, by the Commissioner will be covered, and only in respect of the duties specified by the Commissioner. But I would add that it is only something done in good faith only. Maybe my colleague can clarify this. In 58 bracket 2, it says that the subsection does not affect the liability of the government for the act or omission. So under 58 bracket 1, it stated that a person is not civilly liable for an act done or omitted to be done by the person in good faith. But if there's a legal liability, subsection 2 deals with it because it doesn't affect the liability of the government for the act. It's just that the liability is not shouldered by any individual. So it applies to a public officer or a person appointed by the Commissioner under Section 48(3), these are individual persons. That's from the point of drafting. Maybe Mr. Young can supplement. I have nothing to supplement.
Oh.
Ms. Scott? Sorry, speakers off mic. I accept that, but when it comes to 57(2)(a), that is, well, in relation to whether the duty to make sure that the information is accurate or not, and whether this bill is comply with, whether the ordinance is comply with. I think this is not in line with the role of the commissioner. So can you tell me? So 57(2)(a). Yes, this is a point raised by the privacy commissioner before. After our discussion, the administration has decided to delete 57(2), the entire subsection 2. Yes. Any other concern? I think it would be better to delete it. In 58(1), I have no objection. I find that acceptable. Ms. Sid Ho. In 57(1), just now the legal advisor asked about this. That the government or a public officer is not liable only because, will it be criminal or civil liability? And I remember that somewhere else the term is different. Is not liable. It will read in Chinese commit. So how is it compared to the PDPO? Because if you said that 不觸範本條例 not contravening this ordinance, so it's in relation to whether it's civil liability, criminal liability, and well, liability as a whole. Mr. Young, under 57(1), not liable. Well, since it's not liable, it implies that there is no criminal or civil liability. So why is it not narrowed down to contravention of this ordinance, 觸犯本條例? Ms. Cha? Well, this does not deal with other ordinance. So there is already a context. And in this context, there is no liability. There is no need to read this ordinance because it's already limited to this ordinance. In Chinese, it reads 承擔法律責任, and in English, it's not liable. And it seems that the Chinese carries a wider scope. Maybe it's not consistent with other ordinances. I cannot give you an exhaustive list off the top of my head to argue my case. We'll need some time to find information. But from my recall, not liable only, well, it's rarely seen. It's more frequent when it reads not contravene this ordinance. I will discuss it with the administration. I will ask the DOJ to look. Well, how many ordinances are there that reads not liable? Well, they already said that it doesn't apply to all ordinances. It just gives that impression. In Cap 474, Section 63, and it says the government or a public officer is not liable. And in 436, that's the same. Cap 436 is the Tai Lam Tunnel, Western Tunnel Ordinance. And it says at the outset that the government is not liable because da-da-da. And this is for your reference. There are other ordinances. And of course, I believe that there are other renditions. So on 57, 58, any other questions, or do you accept this or not about the exceptions? If not, let's go back to clause 4. I think we've discussed that. We have 10 minutes left. Let's continue with clause 5. Clause 5 is in relation to the establishment of system. It says the Commissioner must establish and maintain an information infrastructure. That is 5.1. 5.2, it says the system must keep a record of every registered healthcare recipient containing the following. There are 3. First, the index data, say name, date of birth, something that can identify the recipient. Second part is the health data. The third part relates to information that is not A or B. Say, for example, someone who accessed the record. And this is the type of information referred to in C. So this is in relation to the establishment of system in clause 5. No questions? Let's continue. Ms. Quat, it says any other data or information of the recipient. Can you make it clear what other information or data? Is there a scope? It is in the second half of the sentence, necessary for the proper functioning of the system. So is limited. I gave you an example. Say, for example, system management data, statistics, say who accessed which patient's information in the past year. So we need that, and that's why we have C. Say for someone who participated in the scheme and there is electronic records. And if some other information is required of the patient, and if it is denied, does it mean that the patient will break the law? This talks about the type of information kept by the system. A is index data. I think what Ms. Quat was asking is that there is a patient, and the patient only gives consent to 9 types of information when the Commissioner asked for the 10th, and whether the patient has the right to say no. I think that's her question. And in clause 6, you will find the eligibility and obligations of the recipient. Say, for example, you've registered and you may change your contact number, or you may have moved. You will have to tell me. And this may be the 10th type referred to by Ms. Quat, and that is necessary for the functioning of the system. Well, when the patient sign up, there may be some conditions. So yes, it may happen. But I can't give you an exhaustive list. What if the member of the public refuses? He or she will have to withdraw from the system, or he's broken the law, or what? I don't think there is a crime. But that person might have failed to meet the conditions, and the commissioner has the power to suspend the case or even cancel the case. So there is no legal liability, civil or criminal. Well, as I said at the outset, this is a voluntary scheme. And if refusal to provide certain information will result in the system not being able to function, then, well, in effect, the patient cannot participate. So it's the case that if the patient refuses certain things, and as a result the system cannot function, then he will not be allowed to participate. Say, for example, a patient says, you can't keep this information of mine and that information of mine, and as a result the system cannot function, then you will turn the application down. Well, say for example, if you require certain service from me and that I cannot provide it, then it can be a withdrawal. If a request is made of me and I cannot provide that, then that will be it. But that person can continue to exist in the system. And I think in most cases that person will choose to withdraw from the scheme. Well, I find it acceptable because it says that it is necessary for the proper functioning of the system, so it's not any other information. Thank you. We have 2 to 3 minutes. Will we start clause 6 or should we continue next time? Ms. Ho, you have a question? A silly question. Not something to do with clause 6. I was going through the blue bill and I found that in the schedule, healthcare professional, it doesn't include speech therapists and audiologists or psychologists. But it doesn't say that they are excluded. But psychological assessment is very important. So healthcare professionals. So I don't know whether there are other healthcare professionals other than psychologists that are not included. So it's not a silly question, it's just that you have jumped a lot. What if there are certain disciplines that are not included and they are important? Does it mean that this bill does not cover impairment assessment or psychological health? But that is important. I think when it comes to psychological health or psychological assessment, protection of privacy may be more important than when it comes to physical conditions. Will you be able to give us an answer, Mr. Chen? Well, after registration, we will move on to who are healthcare professionals. When we define healthcare provider, it's a healthcare provider that engages some of the 13 healthcare professionals. So it's not about the professionals in Hong Kong. It's just about the type that are recruited by the healthcare provider, because we have to make sure that only healthcare professionals have access to the health record. So when we look at whether it is a registered midwife or registered nurse, we can refer to the register to verify the information. So if one of the healthcare professionals in the 13 as set out in the schedule is employed by a healthcare provider, then is an eligible healthcare provider. Maybe say for dietitians is not included in the list, then it doesn't mean that they are not related. It's just that it's not related to the healthcare provider. So we have to find out whether a healthcare provider only engage a dietitian or psychologists, and as a result, they cannot participate in the scheme. The time's up. So does it include psychological health? Please give us a quick answer. Maybe next time you can give us an answer, it can be a detailed answer so that we don't overrun. The next meeting, the 6th one, we will continue. Thank you.